Welcome to our Fashion Law webinar. My name is Stephen Sudkin, and it is my privilege to lead our Fashion Law group here at Fox Williams. We're going to be hearing today from a number of members of our Fashion Law group. Our first speaker is Tom Morton, who's a senior associate in our real estate department. Tom's going to be talking about tenancy agreements for fashion and retail tenants and why it is important to perform yours and how to do so. Tom's then going to hand over to Hannah McCullagh, who's an associate in our Commerce and Technology department. Hannah will be talking about the future of fashion. How will sustainability laws impact your business? Hannah will then pass to Scott Steinberg, who's a senior associate also in our Commerce and Technology department. Scott's going to be telling us about it's not simply about registering a trademark, protecting your intellectual property, and what you need to know. And then Scott will be handing over to Sarah Carlton, who's a senior associate in corporate. Sarah's going to be giving us some market insight into 5 things we are seeing in the corporate landscape at the present time. Following our webinar, if you do have any questions or if there's any matter which you would like to discuss, please contact any of the speakers at Fox Williams. Our contact details can be found at www.foxwilliams.com or www.fashionlaw.co.uk. I do hope that you enjoy our webinar. And now let me pass over to Tom.
Hello, thank you, Steve. My name is Tom Morton. I'm a senior associate in the real estate department at Fox Williams and a member of the Fashion Law Group. I want to talk today a little bit about landlord and tenant law, obviously focused primarily from a retail fashion tenant perspective. Tenants of business premises, as I'm sure many of you will be aware, are not necessarily property people, but obviously a business needs a physical presence on the high street, and if it does, it will more than likely need to take a lease. Business leases are scores of pages long. They're full of jargon, essentially very bad bedtime reading. So that's really the reason for the strap line here on the slide. Your lease unfashionable but important. A lease for you is a necessary aspect of running your business. The problem tenants often find with that, though, is many landlords are property people. Their business is making money from property. They have portfolios, they have lawyers, they have surveyors, and they like property law because they can leverage often their position against unsuspecting tenants. So if we could just move on to the next slide. I'm going to talk about break clauses briefly. They're a real potentially problematic area of landlord and tenant law for unsuspecting tenants. We're going to touch on breaches of covenant, terminal dilapidations, and I'm also going to talk very briefly about keep open clauses. I've got a very short amount of time, so we can't necessarily go into any real detail. So what I prefer to do is just to try and flag some of the more important aspects that you need to be aware of from a retail tenant perspective. So if we could just move on to the next slide. Break clauses. We all know what they are. They're essentially a contractual right to end the lease at the end of the term. They are not as simple as they look on the tin. And remember, landlords are property people, so they know the rules and they can often exploit them. The big point really to take away here is that a failure to serve a break notice properly in the correct way on the correct party can have quite serious consequences. There are lots of difficulties surrounding service of these notices and notices generally under leases. So you really shouldn't take them too lightly in the event that you find yourself in a position where you need to serve one. If you take nothing else away from my segment, then please take this away. Don't serve a break notice yourself. If you're in a position to serve one under your lease, it should always be done by a lawyer. Some of the things that can go wrong, for example, have you served the notice in the correct way? Often tenants will serve break notices by email, and that's usually an invalid method of service. Leases generally specify that email isn't valid service of any document or notice under a lease. And worse still, there are general provisions surrounding the service of notices set out, usually in a dark and dusty corner of the lease, and not cross-referenced to the break. It's often difficult to find out whether you're serving on the correct party. So what does the lease say? Does the landlord have agents? Potentially the freehold reversion may have changed hands between landlords. You might be dealing with a different entity. The landlord may have changed its registered office. And of course, one has to serve a notice it specifically in accordance with the terms of the lease. Otherwise, it risks invalidity. So that's the very brief points on service. Moving on to once you've served your notice, you've then got to ensure that you comply with any break conditions, and those are usually found in the break clause itself. And primarily there are two. The first is payment of rent up to the break date, which is usually a condition of the break taking effect. And the second is to give up vacant possession. So the payment of the rent up to the break date is always a perennial problem for property litigators like myself. You often see tenants paying rent pro rata up to the break date, where the break falls between two usual quarter days. And if you do that, you run a very serious risk of the break being invalid. So when serving a break notice and when making sure on the run up to the break date, you need to make sure that you're paying the full quarter's rent or the full month's rent if the break falls mid-quarter. Otherwise, you could risk invalidating it. The other point, of course, is returning the property to the landlord. So think very carefully about, returning keys, returning all key fobs, key codes, other means of access. Make sure that the property, the lease, is free from derivative interest. So one would hope you haven't perhaps granted any subleases, but if you have, they would need to be dealt with well in advance. And things like cancelling security, cleaning contracts, etc. You don't want to be in a position where you think the lease has come to an end and that then you've handed the landlord an argument to say that it possibly hasn't. So if we could move on to the next slide, if we can. Breaches of covenant. If you find yourself in breach of the terms of your lease, the first thing obviously to do is to take some legal advice. Could be for whatever reason, it may be a liquidity problem. You may have failed to make a rent payment or otherwise in breach of for example, the repairing covenants under the lease. Landlords have two options in these circumstances, and it's quite useful to know a little bit about how they work in practice. The first is that the landlord could sue you to ensure compliance with the terms of the lease. So, for example, you haven't paid your rent, the landlord could sue you for the money, or if, as in my previous example, you haven't complied with the repairing covenants in your lease, the landlord could take steps to make you comply with the lease terms. So that's option one. Option two is what we normally refer to as the nuclear option, which is forfeiture. Now, forfeiture of the lease is as scary as it sounds. The landlord can do it either by what's called peaceable re-entry or by issuing forfeiture proceedings at court. Now, taking those two things in turn, I haven't got time to go into the legal details. So I think the takeaway points really are: if a landlord is bringing proceedings against you for breach of covenant, proceedings can be intimidating, but remember the court process moves very slowly. That can often play into a tenant's hands, and court proceedings are also expensive. And in my experience, landlords know both of these things. So it's quite useful to know that landlords are often quite slow to take steps against a tenant in default. And if you are sensible and if you approach matters in the right way, you can often find that if you're transparent with your landlord, there are essentially deals that can be negotiated where otherwise that you might find yourself in proceedings. So moving on to, I want to talk very briefly about keep open clauses. I get asked about keep open clauses a great deal by tenant clients. And a keep open clause is a positive covenant to keep open, usually during business hours. So what can the landlord do if you find yourself in a position where you can't trade, and you have to close, but your lease obviously continues? Well, the answer is that a landlord can claim damages for breach of a keep open clause, but he cannot ask the court for an injunction to require you to open. Basically, the reasoning for that is in the case law that it's not in the public interest to force someone to carry on a business at a loss, if there's a plausible alternative by which the injured party can be compensated, and that of course means damages. And the interesting point about that, of course, is unless you're a sort of anchor tenant in a large shopping centre or something of that nature, it can often be quite difficult for landlords to prove loss. Whilst they might be able to prove liability easily enough, it will be very difficult potentially for a landlord to quantify its loss. The other option for landlords for a tenant in breach is forfeiture. As I say, that can happen by proceedings or simply by changing the locks. That's the landlord's most destructive weapon. But it's important to know that for any breach of the lease other than non-payment of rent, a landlord needs to serve a notice called a Section 146 notice on a tenant, requiring that the tenant remedy the breach. So you may well have, unless your breach of the lease is non-payment of rent, you ought to have some time and some notice to enable you to take some legal advice. So that's very quickly a trot through those two concepts. If we could just move to the next slide, if we can. So terminal dilapidations, lawyers often refer to this as the sort of the unwelcome gift at the end of the tenancy. What it is, it's essentially a final bill, a final payment from tenant to landlord in respect of damages for alleged breaches of repairing covenants during the term of the lease. That could be repair, it could be redecoration, reinstatement, but it's usually all three. And put simply, dilapidations are the cost of the works required to put the property into the state that the tenant should have left it at the end of the lease. And how this normally happens is a landlord will employ a surveyor, and the surveyor will inspect the property and inspect the lease, and will draw up a schedule of all of the items of repair and reinstatement, which the landlord says the tenant ought to pay for. So as a tenant, when you're exiting your lease, you should expect a schedule of dilapidations from your landlord. What you should not do is take the number at the bottom of it at face value. This is the landlord's number is always larger than it might be. So it's important to take your own legal and surveying advice, and I would always recommend to a tenant prior to the end of the lease to retain a surveyor to do a survey of the property and to give detailed dilapidations advice in the run up to the end of your lease. There is a protocol for dilapidations that things don't move particularly quickly. Once the landlord has served a schedule on the tenant, then the tenant's got 56 days to respond. The response would usually be a counter schedule, which would challenge the landlord's costings and deal with other potential legal issues with the landlord's claim. Now, I've dealt with very many dilapidations claims in my day-to-day job. I'm pleased to say that very few of them go to court. But the takeaway for me in dealing with them has really been the key to everything is early engagement with your landlord. So if you are a tenant and you're leaving your property at the end of a lease, it's very important to engage directly with the landlord and the landlord's surveyors. Have the conversation about dilapidations early on, and if you do that, you stand a very good chance of achieving a negotiated settlement without the need for the threat of proceedings. And often it's something that surveyors can deal with, speaking between themselves. So that's a very short overview of some of the main aspects of landlord and tenant law that I deal with on a daily basis. I hope it's been informative, and I will hand over to the next speaker, if I may.
Thanks, Tom, for that. Hi there, everyone, and thanks for joining. As Steve mentioned, my name is Hannah McCullagh, and I'm an associate in the Commerce and Tech team here at Fox Williams. Next slide, please. So today I'm going to talk about sustainability legislation in the UK and the EU, and in particular the issues of greenwashing, including the UK Green Claims Code and also the new UK Digital Markets Competition and Consumer Bill, and also two new pieces of EU legislation, the EU Corporate Sustainability Due Diligence Directive and also the EU Product Passport regime. Next slide, please. So greenwashing, well, most people know what this means, but they don't necessarily realise how onerous the laws in this area can be. There have been a lot of examples of fashion brands getting into trouble for it in the news lately. You may have seen that Nike is currently facing a greenwashing claim in the US courts in relation to certain products which it has marketed as being eco-friendly. Even though they weren't made from sustainable materials. H&M have also got into trouble in the EU in relation to their Conscious Choice range, which it branded as being made from recycled products, but no evidence of this was provided to consumers. Next slide, please. So, what is required of UK businesses to stay on the right side of the law? Well, the UK Competition and Markets Authority has developed the UK Green Claims Code, which was published back in 2021. And this code is centred around 6 key principles, which I've set out on the screen. Unfortunately, I don't have time to run through them all, but essentially, the code requires businesses to ensure that any environmental claims that they make are backed up with data. They are clear, complete, and consider a product's entire life cycle, right through from production to disposal. And since the Green Claims Code has been in operation, the UK Competition and Markets Authority has pursued a number of very large fashion brands such as ASOS, Boohoo, and George Asda in relation to certain collections that they have produced. Next slide, please. So what are the current enforcement powers of the UK CMA? Well, currently the enforcement powers of the CMA are limited, and that's because the CMA must bring legal action against corporates who they feel are in breach of consumer law directly via the courts. So generally their work will involve conducting a review of business practices against the code and then issuing directions or recommendations to remove certain products from the market. With this, obviously, comes the downside of negative publicity for brands to worry about, which, as in the case of ASOS and Boohoo has been established, can have a significant impact on consumer behaviour. Next slide, please. But coming through the pipeline, we have the UK Digital Markets Competition and Consumer Bill. It's currently going through Parliament, and the intention behind this is to significantly strengthen the CMA's powers. So when this bill becomes law, the CMA will be able to directly enforce its decisions regarding greenwashing, rather than having to go through a lengthy court process. And crucially, it will also be able to directly issue fines up to £300,000 or 10% of a business's annual turnover, whichever is higher, in the event that businesses are found to be in breach of consumer laws, including the UK greenwashing laws. Next slide, please. So, what should you do to prepare? Well, in general, we would recommend that businesses should think about deploying 2 strategies in parallel. First is a sustainability strategy. This will involve an internal review exercise, most likely involving lawyers, of a business's supply chain in order to ensure that the internal documentation that they produce support sustainability clause claims that are made in the case that they were ever subject to scrutiny. Second, a communication strategy is imperative in order to ensure that any environmental claims that are made by businesses comply with the UK Green Claims Code and are accompanied with evidence to back those claims up. Next slide, please. So next, I'm going to move on to two new pieces of EU legislation in the pipeline, which fashion businesses should be aware of. The first of those is the EU Corporate Sustainability Due Diligence Directive, and this is expected to bring about major change for corporates of all sizes in terms of their reporting requirements. Now, on the face of it, given that this is an EU piece of legislation, UK businesses may think that this will not apply to them following Brexit. But the reality is unfortunately quite the opposite, and it will apply to EU and non-EU businesses which meet the thresholds set out on the screen in front of you. But crucially, also UK and non-EU businesses which don't meet the thresholds but are part of a supply chain with businesses which do, will need to comply. And that's because they will need to contribute to the reporting obligations of the supply chain as a whole. This will therefore have similar reach to big EU pieces of legislation, such as the EU GDPR, which is said to have extraterritorial effect. Next slide, please. So what will businesses be required to do to comply? Well, directors of businesses will be required to play an active role in conducting due diligence in order to identify key areas of risk which their business and the entire supply chain in which they operate may have on human rights and the environment. And once these risks have been identified, they will then be required to establish processes to prevent, mitigate, and account for the impact of those risks. Next slide, please. So moving on to consequences of non-compliance, given that this is an EU directive, it will be up to member states to make this directive effective in their own national laws. Therefore, compliance will be monitored at a national level. However, in general terms, we can expect fines and also, of course, risks for directors, as they may be found to be in breach of directors' duties. And for those lower down in an affected supply chain, it's also likely that they will be required to take on contractual risk, whether that's in the form of warranties or indemnities, in order to confirm that the reporting information they have provided is correct. This, of course, could result in smaller companies being on the hook for potentially significant damages in the event that the information they have provided is untrue or misleading. Next slide, please. So when will the directive come into effect? Well, it's expected to come into force by 2025, following which each of the 27 EU member states will have 2 years to implement the directive into their national legislation. However, you should be aware of existing regimes. We're aware, for example, that France and Germany have already adopted national sustainability laws, which are similar and in some cases go even further than what is proposed under the requirements of the EU Corporate Sustainability Due Diligence Directive. Next slide, please. And finally, I'm going to just touch on the EU product passport regime. It's intended that this will be implemented into EU legislation via the Eco-Design for Sustainable Products regulation. And the aim of this really is to enhance sustainability and the transparency of supply chains across the EU in order to allow consumers to make educated choices about the products that they buy. Now, again, unfortunately, exact requirements are to be confirmed at a later date, but the proposal suggests that certain businesses will be required to provide detailed product information about the life cycle of their products. That'll be from information about how materials are sourced, the manufacturing processes that they have undertaken, labour and environmental standards that have been followed, the carbon footprint of that product, and as well as guidance on how to repair, reuse, or recycle that product when consumers are finished with it. And it's expected that all of this information will be required to be provided on a QR code, which will be displayed on product labels provided at the point of sale. Next slide, please. So who will it apply to? Well, it will apply to any UK and companies from outside of the EU which manufacture or sell products into the EU. But like the previous piece of EU legislation I mentioned, it will also have much wider effect. Therefore, it'll apply to UK companies and companies outside of the EU, which are part of a supply chain for products which sell in the EU. And the reason for this is that they will have to provide information to businesses higher up the chain, which are required to comply and provide that information. Next slide, please. In terms of timeline, it was originally expected that the regulations would be approved by as early as 2024, but there has been, unfortunately, delay, and the regulation is currently forecasted to come into effect by 2026 or 2027 on a phase-in basis for certain products. Now, at the moment, it's expected that companies in the battery and textile industries will be the first product group that will be required to comply. And at the moment, we think they're targeting 2030, but it could very well be earlier than that. You should also be aware that, again, France is ahead of the game in this respect, and they aim to introduce product passports for goods sold into France by as early as 2026. Next slide, please. So, with all that in mind, I thought I would share our top tips for compliance with the EU Corporate Sustainability Directive and also the EU Product Passport Regulation. So I think the first thing to do is to really familiarise yourself with the requirements of the proposed legislation. You should also discuss the requirements with your customers and your suppliers so that they too know their obligations. And you should also recognise and prepare for the fact that you may be required to invest in technology to comply with the legislation, whether this is in the form of technology to support your reporting obligations or whether to produce QR codes to comply with the EU product passport regime. Next slide, please. So in conclusion, that was obviously a bit of a whistle-stop tour, and I haven't been able to go into huge amounts of detail. But I think the key message to take away from my talk today is that transparency is key, and the sooner that you get to know your supply chain, the better. I'm now going to pass on to Scott.
Thank you, Hannah. My name is Scott Steinberg. I'm a senior associate in the intellectual property team at Fox Williams. And so I'm going to talk about intellectual property. And it's not simply about registering a trademark, protecting your IP. Next slide, please. So let's start first with some common myths that you may have heard before. For example, it's okay if you make 5, 6, 7 changes. We'll be discussing later why that's not the test. Everyone else is doing it, so it's okay. That didn't really work as an excuse at school, so it doesn't now. That product was around for years. Copying is no problem. IP rights are too expensive and time consuming. They don't always have to be. For example, a UK trademark can be relatively cheap. And the factory said it was okay. Please do not rely on third parties. Next slide, please. So trademarks, what are they? A trademark is something that distinguishes goods and services of, say, your company from those of another. For example, at the bottom, there's various different types of trademarks you can have. Adidas has a word mark, the stylized word mark as shown on the screen, a logo version, and the slogan, "Impossible is nothing." They are territorial rights. So if you have protection in the UK, then that will cover you in the UK. If you have protection in the EU, that will cover you in the EU, but not the UK, and so on. So you should protect your trademarks in the territories that you're using. And duration, they last for 10 years, but they can potentially last forever if you keep renewing every 10 years. Although that's subject to provisions where if you're not using, then a trademark can be challenged after a certain amount of years. Next slide, please. So trademarks, let's talk about oppositions and infringements. So you can either oppose a trademark application to try and stop it from being registered, or you can bring a separate action for trademark infringement. For example, if someone else is using your trademark and you want to stop them doing that. The tests are fairly similar as a sort of general overview. We have what's known as double identity, where you've got an identical mark for identical goods and services. Just to give you an example, in the Bentley Clothing and Bentley Motors case, which reached the Court of Appeal, which we handled, it was actually found that Bentley Motors combination sign, which is shown on the slide on the right, would be perceived as two distinct signs used simultaneously and was an identical mark in that case. The next test is, do you have a similar or identical mark for identical or similar goods or services? But this time you need to show that there's also a likelihood of confusion. And then do you have a similar or identical mark? This time you don't need to prove there's identical or similar goods or services, because this is about your reputation in a territory and unfair advantage or detriment to distinctive character or detriment to repute you need to prove. So as an example, in the Jack Wills and House of Fraser case, the two logos are shown on the screen. It was a sort of pheasant that was had accessories associated with an English gentleman, and that's why the marks were found to be similar. Similarly, there was considered to be unfair advantage because there was a sort of, they said, a subtle transfer of the image, increasing the attraction without sort of their own advertising spend or promoting the goods themselves. Next slide, please. Oh, sorry, can we go back a slide? I forgot to say something I should probably. So another way of sort of resolving disputes is that it's possible to coexist. So this is why, for example, you will find Polo. You've got Ralph Lauren, you've got a Mint, and you've got a car. Next slide, please. Design rights. So this kind of looks like a complicated table because they can be quite complicated, these rights. But I'm going to try and summarize a few of them, not including the Brexit new rights. Sort of in let's do a quick whistle tour. So starting with UK unregistered, these last for 10 years from the date they were first put on sale, or 15 years from when they were first recorded, and it's the shorter one. But those time periods are subject to what's known as a license of right in the last 5 years, which means that someone can approach you for a license, and that needs to be granted on reasonable terms. It covers the shape or configuration of the whole or part of an article. So that as a sort of general view, this doesn't work because of sort of the other rights below. But designs are more to protect 3D objects, whilst copyright is sort of to protect 2D. So that's something you can keep in mind to try and differentiate them. And for infringement, you need to prove copying for unregistered rights. I should also say that UK unregistered does not include surface decoration. So that's a big advantage of the other rights. And by surface decoration, we mean sort of the colouring on the designs, and I guess, as it says, the decoration on the surface of the design. There are other exceptions as well. For infringement, that's where you copy articles exactly or substantially to the design. And to have a UK unregistered design, you need something recorded in a design document, or you make the article, and you need something that's original. It's not a sort of, you put in sufficient time, labor, and skill, and it's not commonplace in the design field at the time of creation. Moving on to the other rights, these are all, or they were, harmonized under EU law. So they're fairly similar, other than the differences between unregistered and registered rights. So EU unregistered rights last for 3 years from the date they were made available to the public, whilst UK registered and EU registered last for 25 years if they're renewed every 5 years. So a major advantage of registering your rights, as can be seen in the table, is that you get longer design rights. What do they cover? They now cover surface decoration, all three of these rights. As you can see, it includes colours, texture, and so on. So that's why in some respects they can be better rights. And then the infringement test for EU unregistered rights is that they produce on the informed user the same overall impression, and you also need to prove copying for unregistered rights. So another advantage of registering your rights is that you don't have to prove copying, you just have to prove the overall impression test has been met. That does take into account design freedom. Now, to get any of those designs, an EU unregistered, a UK registered, or EU registered, you need to show that there's a novelty, there's no identical design or design differing in immaterial details available to the public before the date of your design. And individual character, you need to show that the overall impression produced on the informed user differs from any design made available to the public. Again, this is subject to the design freedom in that area. I have on screen an example of from Lambretta and Teddy Smith. So in this case, it was found that there wasn't a design right in the combination of colours. And that's just sort of to illustrate the example of surface decoration not being protected. Next slide, please. So copyright, the more sort of 2D right, as I said, as a general overview. The major advantage of unregistered rights, I suppose, is that it's automatic once you meet the requirements. You don't have to register them. So for copyright, you need something that's original and in a tangible, as in recorded form, because there is no protection for the form of expression or ideas in intellectual property law. Then you need a type of work. So there's some examples here on the screen. That would be, for our case, probably a literary or artistic work. So literary, something that's written, and artistic sort of images or photos and so on. They generally last 70 years plus the life of the author, which is an incredibly long time for a right, so it can be a very powerful right. There is also international protection. So via, for example, the Berne Convention, you should be able to get the minimum amount of copyright protection in another territory as you'd have in your own territory. And then there's something called moral rights, which are sort of related to copyright, where you have the right to be identified as the author, for example, and the opposite, to not be identified as the author, and to object to derogatory treatment, such as, for adding, deleting, altering, or adapting a work to distort or mutilate that work, as it's said in the sort of definition. Next slide, please. So copyright infringement, how does that come about? So that involves where you copy the whole or a substantial part of the work without permission. It's a factual assessment, so it does depend on the facts. And also it's more of a qualitative test rather than a quantitative test. So before we said it's not about 5 to 7 designs. Here it's about the quality of what was taken. So as an example that helps me, if you have a recording, I don't know, 5 seconds of a football clip, and it includes the goal, that would be qualitatively more infringing than 5 seconds of just a couple of passes. There are exceptions known as permitted acts for copyright, but those don't appear to be too relevant for the purposes of this talk on fashion. But I will give you the example shown on the screen of Response Clothing and Edinburgh Woolen Mill. In that case, the claimant supplied the defendant with tops for females, made of a fabric with a wave design. The claimant raised the price so that defendants sold tops from other suppliers, incorporating other fabrics, and the defendant supplied samples to other suppliers as well. The wave fabric was found to be a work of artistic craftsmanship, which is a type of copyright work. And as a result, there was infringement found in this wave design fabric, which was quite surprising at the time, because it could be inferred that there was direct or indirect copying, and that a substantial part had been copied. Next slide, please. So practical steps. tying this all together. Please do keep records. This is a really helpful way of proving either that you have the unregistered rights or that your rights have been infringed. You should consider registering trademarks or designs. I've outlined a few of the advantages of registering rights earlier in this presentation. You should also check if third parties have registered rights, because obviously that could be a problem for your business. Don't forget that there may be unregistered rights as well. So even if you think it's clear and you've checked registrations, there may be some rights out there, and you should review your contract. So as an example, generally in IP, a employer will own the IP in rights that an employee has sort of developed in the course of their employment. So it can be handy to put in contracts, especially with contractors, to clarify the position of IP and who owns that IP. Thank you very much.
Thanks so much, Scott. Hi, everyone. My name's Sarah. I'm a corporate lawyer at Fox Williams, and I'm going to touch on 5 things that we're seeing in the corporate landscape at the moment relevant to fashion businesses. Next slide, please, Dan. Great. So, that's just an overview of what I'm going to cover in this webinar. So looking at bank scrutiny of borrower board appointments, government support schemes, which are of particular interest for insolvency practitioners at the moment, preparations before shareholder disputes. I'm also going to touch on the dynamic shaping M&A timetables, and also preparation for a seamless M&A sale process. So looking at the next slide, and first of all, banks reviewing borrower board appointments. Well, I'm sure you've all seen what happened in the Nigel Farage case, where he was dropped by his bank Coutts. Now, in that case, Farage was considered a politically exposed person, so someone who holds or has held public office and therefore may be more susceptible to bribery or corruption, and is therefore subject to extra checks and monitoring by the banks. Now, that's quite an extreme case, but in our day-to-day practice, we are seeing cases of banks undertaking huge amounts of KYC, or know your client checks, on borrowers in respect of both the corporate group structure, but also the corporate directors, the directors appointed. Now, a recent example we had was where a credit renewal came up for one of our clients, and the bank decided that they weren't going to renew the credit facilities on offer due to a particular director being on the board of that company. Now, this particular director did have history with another insolvent company where he had actually come off the board whilst the company was going insolvent. Now, in that case, we did appeal the decision made by the bank, and to resolve the matter, we actually arranged for that director to come off the board whilst the credit facilities were renewed, and then the director was actually reappointed later down the line. So what we're generally saying to clients at the moment in particular is do your internal due diligence before applying for finance or finance renewals, particularly when time is critical. So do consider whether any of the company directors have a history that could be questioned by the bank, and therefore that might hold up KYC processes. And if so, have a think about how you might deal with that ahead of time. Right, moving on to the next slide, please, Dan. Looking at government support schemes. So the UK government, recognising the economic challenges presented by the COVID-19 pandemic, implemented vital business funding support schemes, which delivered much needed liquidity to businesses. And I'm sure you're all aware, among these initiatives included the Future Fund, the Coronavirus Business Interruption Loan Scheme, the Bounce Back Loan Scheme, and some others as well. Now, unfortunately, in numerous instances, the repayment of these loans really became a tipping point for company insolvency. So, for example, taking the Future Fund, as at September of this year, as at the end of September of this year, 146 companies that had received funding from the Future Fund had succumbed to insolvency, and at least 3 of these companies were fashion businesses. In the case of a Future Fund loan, the end of the term loan triggers an email to the business, and if conversion isn't achieved before the deadline, the Future Fund mandates repayment. Now, in a challenging fundraising environment, and with the difficulty of selling a company burdened by a big loan on its balance sheet, insolvency unfortunately becomes an undesirable alternative. Communication with the future fund can become challenging, primarily conducted through the company's online portal, which lacks a direct email or helpline seeking modifications to debt terms. Notably, companies approaching insolvency are drawing heightened scrutiny from the Insolvency Service, particularly those that have benefited from COVID support schemes. And this intensified attention stems really from concerns about potential misuse or abuse of these support systems. Hundreds of directors who have received loans that they weren't entitled to, or who dissolved companies improperly to avoid these repayments, have also been disqualified. Now, the Insolvency Service will delve into how the funds were utilised. They'll examine whether they actually serve the intended purpose, so whether directed towards retaining employees, covering operational costs, or other approved uses. To navigate the regulatory scrutiny, companies heading to insolvency are advised to maintain good records and, of course, adhere to all support scheme conditions and be ready to transparently demonstrate to the Insolvency Service how the funds have actively supported the business during particularly challenging times. Right, moving on to the next slide, please, Dan. So observation number 3, I suppose, preparing before a shareholder fallout. Well, disagreements among shareholders and founders, they're not uncommon. When these disputes arise, they throw up often emotional responses, but also have potential for real complex legal issues as well. The multifaceted roles played by individuals, whether as shareholders, employees, directors, or consultants, can be especially convoluted in owner-managed businesses. And the current cost of living crisis has heightened the stress on business owners, leading to a surge in client inquiries seeking guidance on navigating shareholder conflicts. Now, often disputes in the fashion industry are kept private, but one that was reported in the Sunday Times was the Ralph and Rosso dispute with shareholder Candy Ventures, and Fenwick has also had its fair share of feuding shareholders, which has also been publicly reported. Now, the most efficient resolution to such disputes often lies in a negotiated solution, importantly, whilst goodwill still prevails. Now, typically, these negotiations result in one party agreeing to exit the business, transferring their shares to the remaining shareholders. And proactive preparation is crucial in anticipating potential disputes. The initial inquiry that we might do often revolves around understanding the company's documents, so looking at the articles of association, any existing shareholders' agreement. And these documents would typically outline mechanisms for compulsory share transfers in specific situations. And these documents should or might include robust dispute resolution mechanisms, such as suggesting that the parties go to mediation to assist with amicably resolving conflicts. Now, ensuring statutory registers are up to date and in order is paramount. These registers determine the legally recognised shareholders in the company. Now, unfortunately, in instances where negotiations break down and no mutual agreement is reached on share acquisition, winding up the company could be the only viable option. Next slide, please, Dan. So looking at the dynamic shaping M&A timetables, and just to outline some general headlines on the M&A landscape at the moment. So M&A activity hit a peak in 2020 and it's generally ebbed and flowed since then. In 2022, there were numerous distressed M&A transactions, as you would expect, particularly in the fashion sector. And in the first half of 2023, there was a general decline in deal volumes from about 4% from already subdued levels from the second half of 2022. And what we're seeing is deals are taking longer to get over the line. So why is that? Well, from a buyer's perspective, securing financing for M&A transactions has become much more challenging. As we know, borrowing is expensive. Financial institutions have more stringent lending criteria, and the process of obtaining funding is more intricate and time-consuming. Buyers are often much more cautious in deploying their capital, leading to a more thorough evaluation of financial structures and terms. And what we're seeing is buyers generally becoming more risk averse, and this means increased scrutiny on due diligence processes, and hence due diligence processes getting more drawn out. Buyers are also looking to insurance to cover specific or general risks on a transaction. So when insurance is required, this takes time to get in place, you're dealing with a third party, and there are just more logistics in terms of progressing the deal to completion. Now, from a seller's perspective, generally it's necessary to work much harder as a seller to prepare for upcoming sales. And I'm going to touch on this in a bit more detail in my next slide. But generally, sellers must anticipate a greater level of scrutiny from buyers and funding sources in order to avoid price reductions and to actually get that deal over the line. Now, we're suggesting and chatting with clients and sellers in particular to avoid overly aggressive sale timetables, which would limit management's ability to adequately plan, prepare, and optimize ultimately the business before it hits the market for sale. Now, the elephant in the room, the pricing gap, the valuation gap between buyer and seller pricing expectations has widened, and this ultimately pushes back deal timetables or even pulls sale processes altogether. As you might have seen in the press, in respect of June, the footwear brand, they appointed KPMG to find investors to take on the founder's controlling stake in the business. And the sale process has been delayed despite bids from buyers, Next, the Aurelius Group and other manufacturers, as the offers just didn't match the valuation that the founder wanted for his share of the business. Right, moving on to my final slide, preparing for a seamless sale process. So as mentioned above, sellers are having to work much harder before going to market due to the pressures that the buyers are facing. And hence we found it really important for sellers to take the time to look internally at their business before starting a sale process. So you might call that seller due diligence. And in the event that a buyer would uncover things during the buyer's due diligence that make them feel uneasy or they're not quite sure about, they will seek to mitigate these risks through various means. So they will seek to increase contractual protections in documents. They may look to insurance to provide solutions to address specific identified risks. And ultimately, these additional protections slow down deal timetables or could cause a deal to fall over. Now, as I've set out on the slide, I just wanted to highlight a few areas that you can focus on as a seller when you're thinking about or preparing for a sale. So the first being to check that your statutory registers are in order, as I mentioned earlier, and check that they accurately set out share movements and the current shareholders in the company, because this is one of the first things that buyers will ultimately look at. And as my colleague Scott has talked about on this webinar, ensuring any trademarks are registered and resolving any pending or potential IP infringement issues. Being able to identify and assess any ongoing or potential litigation and have a plan in respect of resolving or at least how to approach these issues with a potential buyer. Reviewing any real estate holdings, leases, and again, identifying any possible property issues, dilapidation issues. And my colleague Tom touched on a few points there. Reviewing employment contracts and agreements, and again, any issues in relation to employment terms, putting employment contracts in place if they need to be in place prior to a deal. And importantly, collating and retaining relevant records and documents in order to facilitate a seamless transition of information from you to the buyer in the sale process. And of course, engaging with a team of experts can really enhance the success of any pre-sale cleanup process and contribute to a more seamless and hopefully successful M&A transaction. And that's all I wanted to touch on today. I'm going to hand back to Stephen Sidkin. Thanks.
Thank you very much, Sarah, and a big thank you to Tom, Hannah and Scott for their contributions this afternoon. As I mentioned at the outset of this recording, if you do have any questions or if there are any issues that you would like to discuss, please do contact us. Our contact details are at www.foxwilliams.com and www.fashionlaw.co.uk. Subject to that, all that leaves me to say is to wish you all a very Merry Christmas and a Happy New Year. Bye-bye.